everyone present here. Today, we all are gathered here on account of Juris Day on National Green Tribunal and Environmental Pollution. The National Green Tribunal has been established on 18 October 2010 under the National Green Tribunal Act 2010 for effective and expeditious disposal of cases relating to environmental protection and conservation of forest and other natural resources, including enforcement of any legal right relating to environment and giving relief and compensation for damages to person and property and for matters connected therewith or incidental thereto. It is a specialized body equipped with the necessary expertise to handle environmental disputes involving multidisciplinary issues. The tribunal shall not be bound by the procedures laid down under the Code of Civil Procedure 1908, but shall be guided by principles of natural justice. Now, I would like to invite Dr. Kalpana to present the green token of our to a guest as a gesture of gratitude. A legal practitioner with an experience of almost 16 years advising and representing clients on a wide variety of matters in the Honorable Supreme Court of India, Delhi High Court, tribunals and appellate authorities including arbitration, NCLT, Green Tribunal, PMLA and Arbitral Tribunal. He has been appointed High Court Services Legal Aid Committee for the past 10 years. He has been handling litigation for seeking damages worth 1,000 crores on behalf of statutory body. He has been successfully handling money recovery disputes for Industrial Financial Corporation of India. He has been successfully handling the litigation for money recovery internationally for multinational companies. He is handling noted money laundering disputes before Money Laundering Tribunal. He has an immense experience in legal drafting such as appeals, writs, suits, complaints, etc. and has almost 50 judgments reported as on date. Some of his reported judgments are DSGMC versus Government of NCT and others, GHPS versus Government of Delhi and others, State versus Nanji Prasad, Arjun and others versus the state, and many more have been added to his credentials which have been passed by the Honorable High Court. Now, I would like to invite Advocate Sukhamrinder sir to embrace the audience with his words.
Well, I'm surprised to know that your company is working today on the second Saturday. This is supposed to be a holiday otherwise. Yeah. Right. Well, you all are aware why are we meeting today, and the topic for the discussion today is environmental laws and national green capital. Without wasting much of time, I will come straight to the topic, because that's more important and we are very short of time. So, we all know what is environment and what are environmental laws as a layman, but as law students, I think most of you are must be final year students or second year students, mid-size, right? So it's now more important aspect for you guys is to understand from the jurisprudence side what actually the environmental law is and how we consider it within law. Is it just the Vatavaran what we talk about, the regular air? Is it that? Is it just about water? Or is it just about the regular gas we consume every day by cars or other things? Or it is much more wider. That's what we have to understand now. So our perspective today is to understand the basics of environmental laws and what is National Green Tribunal, what was the objective to establish National Green Tribunal. It's not that we are a country which has never considered the environmental protection. We have always been that. But with the passage of time and with the growth in the technology, with the development of the society, the pollution has also increased. There have been immense changes in the environment. We see that the migratory birds have reduced coming down to India. We have seen a lot of respiratory issues with human beings. We see a lot of species that have become extinct. So with this, it has been the requirement for all of us to ensure as a fundamental duty that the environment is fully protected for all of us, for the future of the country. In fact, not the country, for the earth. So considering that, so environmental laws were formed. So this is the concern over the state of environment has grown just over 60 years. So what happened that there was a Stockholm seminar which was happened in June 1972 on human environment, and where it was decided that all the countries that are party to that, they will execute certain laws for the protection of the environment. That was a time when they directly dealt with several matters relating to the environmental protection and to have the legislations for particular protection. And in 1986, environmental protection came into being. What was the objective? Objective was to provide for the protection and improvement of environment and for the matters connected therewith. So environment includes what? Water, air, land, and interrelationship which exists among and between water, air and land and human beings and other living creatures, plants, microorganisms and property. So before this enactment, there was no such law. It was Water Protection Act, it was Air Protection Act, it was Forest Conservation Act, but there was no particular statute which was talking about all these interrelated problems. So you can understand with the simple meaning that this statute was brought into being to provide the interrelations, protections of all these issues, which is water, air and land and human beings of course. And of course then plants, microorganisms and properties. Then what is the environmental pollutant, which is very important. So what causes pollution? So we call in the statute as environment pollutant, which means any solid, liquid or gaseous substance present in such concentration which tend to be injurious to environment. It's very simple, right? Anything which is solid or liquid or gaseous substance which is very dangerous for the environment in any form. And then what is environmental pollution? This is the main concern why this act came into being, and they defined it what is environmental pollution, which was never before. So environmental pollution means the presence in the environment of any environmental pollutant. So in case any kind of substance which is solid, liquid or gaseous, which is causing injurious to the environment, that is environmental pollution, which is causing that injury, that is environmental pollution. So what happened that when this act was in process, there was a lot of cases which were filed by various litigants, and the most commonly and popularly known cases are of MC Mehta versus Union of India. You guys must have read about him a lot. So we will quote some of the important aspects of those cases which carved the way for the legislature to understand why do we need environmental protection, and when we have environmental protection, how to elaborate the protection for the entire society. So it is not only limited to certain species. So MC Mehta cases, they derive what is Article 21A, how the life to live is important for us, how the tribunal should act under the Environmental Protection Act, how courts should consider the environmental protection. Right. So excuse me. So this is MC Mehta Union of India, year 92, Supreme Court 382. A public interest decision was filed seeking directions from Supreme Court to the Government of India for exhibition of slides in cinema hall containing information and messages on environment free of cost, spread of relative valuable information relating to environment in national and regional languages through television and radio in regular and short-term programs, and for making environment as a compulsory subject in schools and colleges. So before this, so NC Mehta, what he used to do for every issue, he used to go to Supreme Court under Article 32 Constitution of India, filing a PI. Straight. Because there was no tribunal as such. There was pollution control bodies. So all the cases were filed by him before the Honorable Supreme Court or in some of the High Courts. And considering that High Court had never been very interested in the past, getting into environmental issues, so he immediately used to file the PILs before Honorable Supreme Court. And though this is not the aspect of the Protection Act, but interestingly, this case in which the Supreme Court laid down the law, environmental protected related issues, or like there was a time when you guys were very small, might not have born by that time. So there were advertisements that were shown in cinema that how to clean your environment, how to maintain cleanliness, which is not shown anymore in cinemas. Even the Doordarshan used to show those advertisements after this judgment. So, and cigarette smoking was very much concerned because it was toxic and injurious to the human body for the passive smokers also. So this case law was derived by the Supreme Court, giving a clarification that it is very important that all the advertisements, such kind which are related to the environment, must be shown free of cost. Then in 1988, Supreme Court 1037, with this AIR, NC Mehta again filed another PIR in which central government is empowered to take all such measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling and abating environmental pollution. So in 1988, because of lack of any governmental tribunals which used to maintain, in order to maintain the law and order in the country, in specific to the environmental issues, this central government was given the powers to take all such measures in order to protect. And it is subsequent to this only, Central Pollution Control Board was formed and it was notified under the Environmental Protection Act. This is a very classic case of Goa Foundation versus Diksha Holding, and quote, that no activities which would ultimately lead to unscientific and unsustainable development and ecological destruction at all be allowed. The court must try to protect the ecology and environment. So what this company was doing, they were releasing all the toxic substances into the sea, which was very dangerous for all the causing ecological imbalances and for all the species which were underwater. So the court gave a finding that no, it can't be done, which made any unscientific or unsustainable development and ecological destruction at all be allowed. The court must scrupulously track, because the governments used to permit all this. They were not enacting. See, this is judicial activism. The law student, we all should understand that law student is just not about reading the statutes in particular. We have to read every statute in the light of the Constitution of India. And when we are reading Constitution of India, our foremost important aspect is the judicial activism and how to make sure that judiciary works in the interest of the society. And with these environmental laws, the Supreme Court started laying down all such principles in order to protect the environment, where government was not supporting the statutory compliances. And the government was not supporting, in order to protect the environment, such activities which were really very injurious to the world or to the country at that point of time. So this particular case is one of the classic examples where government was reprimanded by the court. And again, you all must be aware that the CNG buses are, applied all over the state. So this is the case when NC Mehta filed this particular PIL in Supreme Court, in which the Supreme Court gave finding that non-CNG buses, due to the heavy environmental pollution in Delhi, should not be applied. So protect the health of the present and future generation and protect and improve the environment, the non-CNG buses were phased out in order for the use of CNG buses. So again, Supreme Court derived the word right to life from the Constitution in the interest of all the people at large in 2010 in Ahluwalia versus Union of India, that environment is one of the facts of the right to life guaranteed under Article 21 of the Constitution of India, and if the court perceives any project or activity as harmful or injurious to environment, it will feel obliged to step in. So if the moment court finds that there is some activity which is not appropriate, which is injurious to the human or otherwise, the courts can automatically step in. Then that is judicial activism, which is empowered with the constitutional courts, High Court and Supreme Court. So what is the penalty? So we have discussed what is the Environmental Protection Act. We have discussed what is it, but I think the more important aspect is also there. What is the hazardous substance under the Environmental Protection Act? If you guys read the definitions, so whenever you people have to refer to any statute, as a law student, make sure the definitions of that statute are always read by all of you very appropriately, because that's the basic of every statute, where the legislatures have defined what is the meaning of every word particularly to that statute, because that's the meaning of the statute in per se. It says hazardous substance means any substance or preparation which by reason of its chemical or psychochemical properties or handling is liable to cause harm to human beings, other living creatures, plants, microorganisms, property or the environment. So any substance which is dangerous, which is harmful to microorganisms, to human beings, to any living creature, that is inseparable to call it as hazardous substance. And these hazardous substances have been, if you read the Air Pollution Act, if you read Water Protection Act, if you read the Land Protection Act, Forest, all these hazardous substances have been defined under the chemical combinations, that how much combination is dangerous. When we talk about the pollution in Delhi, so we see the air quality. So this air quality is hazardous substance. So the experts, they find out that what is actually the hazardous for us when the air quality pass certain AQI levels. So a person who fails to comply with all the orders passed by the court during the passage of time, under section 15, he was penalized for up to 5 years or for up to 1 lakh rupee or both. So it was to vary. Any questions on Environmental Protection Act? Alright. In fact, when the Environmental Protection Act was framed and it came into being in 1986, the rules and regulations was also formed that how to regulate all these environmental pollution issues. So central government gave the notification of forming Central Pollution Control Board, and they also laid out certain guidelines that standards of air quality should be how much, what should be the standard of water quality, what should be standard of soil quality and various other purposes. It was also formed in that rules that what should be the maximum allowable limits of concentration of various environmental polluted areas, what are the procedure and safeguards for handling the hazardous substances, and what are the protection restrictions on handling the hazardous substance in different areas. If you guys remember, long years ago, I will just say 5 years ago, there was a lot of issue in Mayapuri area when the batteries, those defunct batteries, chemicals were actually, they got interacted with the environment. There was a huge case where various Delhi University professors were also taken to task because that those chemicals were brought in from Delhi University and they were kept in Mayapuri market, and due to it there was huge hue and cry that it was very dangerous, and ultimately the Central Pollution Control Board, they came into being and they immediately took reaction and took away the possession of all the hazardous substances to be disposed of, because that was not the right way to dispose of those batteries. So what Delhi University did was they sold the batteries in the market on the scrap rate without realizing that all these batteries are hazardous substance with the chemicals containing in them. So under these rules, when it was found that it is absolutely illegal what they did, so the cases were filed against all the teachers and all the professors who were part of that. And the prosecution, and immediately the FIRs were registered and steps were taken under Indian Penal Code and CRPC. But interestingly, what happens that this is still not sufficient. This was still not sufficient for the country to control the pollution. There was immense increase of the pollution. The industrial waste was absolutely being flown. I think we can maintain some order in the class. Well, it is just 40 minutes and we can have a lot of discussions after that, right? So, yeah, where were we? The Environmental Protection Act 1986 was just not sufficient for the government to control the hazardous release all across the country. Yamuna is one of the classic examples. There was a lot of industrial waste, solid and liquid and air. There was a lot of garbage which was just not being getting under control due to the population issue in our country. This was getting a toll on the courts in Delhi and across Delhi. Why? Because they were not able to understand which tribunal to be taken to take care of all these issues. So that specific issue got the mist from the entire combinations of the Environmental Protection Act like air, water, then finally Environmental Protection Act 1986. So then at that time in 2010, it was realized that we need to have a tribunal. They were not able to understand what to do, so they thought of having a tribunal. But before that, there was also a statute which was known as National Environment Tribunal Act 1995. So prior to the 2010 statute, there was one more statute which came into being in 95, which was known as National Environmental Tribunal Act 95. But that was a failure. There was no tribunal set up under that. It was not executed, not implemented at all. Keeping in view of that, there was a failure of 1995 Act. The 2000 Act was passed by the legislature. This is it. So what was the objective of National Green Tribunal? The rapid extension in the industrial, infrastructure and transportation sectors and increasing urbanization in the recent years have given new pressures on our natural resources and environment. There has been commensurate increase in the environmental related litigation pending in various courts and authorities. The risk to human health and environment arising out of hazardous activities has become a matter of concern. The UN Conference on Environmental and Development held in Rio de Janeiro in 1992 in June, in which India participated and committed to provide effective access to judicial and administrative proceedings including redress and remedy, and to provide compensation to victims of pollution and other environmental damage. So, because of that, ultimately the NGT came into being, and there was also a National Environmental Appellate Body Authority Act, which was again not executed as I have discussed with you guys. So on the recommendation of Supreme Court, it was felt that we should establish one specialized tribunal to help to handle the multidisciplinary issues involved in environmental cases. Accordingly, the NGT came into being for effective and expeditious disposal of civil cases relating to environmental protection and conservation of forests and other natural resources, including enforcement of any legal right relating to environment. So, the NGT was formed. So, are you guys aware what is the composition of NGT? Are you guys aware of that? How the NGT was, what is the composition? So, NGT composition is that there is one full-time chairperson and there can be 10 to 20 judges, including that chairperson, and their chairperson has to be either a retired Supreme Court judge or any Chief Justice of High Court. And with the recommendation of the chairperson, he can always invite any expert to assist the tribunal in any of the particular environmental issue brought before them. So what is the qualification? The chairperson shall be a retired Supreme Court judge or a Chief Justice of any High Court. Expert member shall have as the administrative experience of 5 years in dealing with the environmental matters in central or a state government. So what's the jurisdiction? So as a lawyers, we should understand what is the jurisdiction of a tribunal. Where can we actually go for a case in the tribunal or not? How the tribunal should, whether we will have the issue of maintainability when we file our petition before the NGT. So we should understand what is the jurisdiction of the court. The tribunal shall have the jurisdiction over all the civil cases which are substantial questions relating to environment, including enforcement of any legal right related to environment is involved. The tribunal shall hear the disputes arising from questions referred to in Schedule 1 of the Act, and application shall be filed within 6 months from the date on which cause of action has risen. If you all have studied CPC, I'm sure you guys must be understanding what is cause of action. Though CPC is not bound to NGT, but the principles are always can be taken by the NGT in order to adjudicate the disputes. So there is a Schedule 1 which is annexed with the NGT Act, which talks about what are the issues that can be considered by NGT. And when we look at the Act, so that includes the Water Prevention and Control Pollution Act 1974, the Water Prevention and Control of Pollution since 1977, the Forest Conservation Act 1980, the Air Prevention and Control of Pollution Act 1981, the Environmental Protection Act 1986, the Public Liability Insurance Act 1991, the Biodiversity Act 2002. So any matter related to all these 7 issues can be filed before the National Green Tribunal. That too within 6 months from the date cause of action has risen. And also includes any civil case pertaining to the environmental protection. So what kind of relief you can seek from there? So it's not that you simply go and say the pollution or a bunker. So what are the powers we have to see under the statute given to National Green Tribunal to decide and to give relief to the petitioner? So tribunal may by an order shall provide relief and compensation to the victims of pollution and other environment damage arising under the enactment specified in Schedule 1. I've already discussed what is Schedule 1. For restitution of property damage or for restitution of environment for such area or areas as the tribunal may think fit. So the tribunal can not only decide the issue by saying whether pollution is happening or not. Tribunal can go to the extent to provide the compensation to the victims. Tribunal can also direct that the property that has been damaged because of the act of the company or the person, that particular property shall be restored. And also tribunal can decide all the reliefs sought under Schedule 1 of the Act, which includes air, water, any kind of disputes and relief sought there. And also the tribunal may, having regard to the damages to public health, property and environment, divide the compensation or relief payable under a separate head specified Schedule 2, so as to provide compensation relief to the claimants and restitution of damaged property. So what tribunal can do ahead is, so there is a village, suppose the entire village has suffered. So tribunal has powers to decide that how the compensation shall be divided to the victims, how it should be given to the victim. So under Schedule 2 of the Act, there is a head which provides compensation or relief for damage may be claimed. So in order to seek a compensation from the tribunal, so we have to move an application that how much compensation we are entitled to receive from the person who has done this environmental pollution, and under that head, the tribunal can carve out what circumstance, how much compensation. compensation shall be calculated and dispersed to the victims accordingly. So, what tribunal can do ahead is, tribunal has powers to decide that how the compensation shall be divided to the victims, how it should be given to the victim. So, under Schedule 2 of the Act, there is a head which provides compensation or relief for damage may be claimed. So in order to seek a compensation from the tribunal, so we have to move an application that how much compensation we are entitled to receive from the person who has done this environmental pollution, and under that head, the tribunal can carve out what circumstance, how much compensation shall be calculated and dispersed to the victims accordingly. Now, one is that NGT is the original court which has an original jurisdiction. That is, you can directly move a petition and you can get the case decided. But it also has the appellate jurisdiction. So the statute is completely overreaching all the issues here. So appellate jurisdiction of the tribunal it is under section 16 that tribunal has appellate jurisdiction over the order passed under section 28, 29, 33A and 13 of Water Prevention and of Control Pollution Act 1971, orders passed under section 2 of Forest Conservation Act 1980, then section 31 of Air Prevention and Control Pollution Act 1971, section 5 of the Environmental Protection Act 1986. And within 30 days, against these orders, one can move an appeal before NGT to seek the relief from the date of the order. Now, one is that we have understood how the NGTs, what is the composition of NGT, what relief it can give, what jurisdiction it has, and also it is appellate body. So what are the powers of the tribunal? No court is complete without the power. No court can exercise any of the reliefs in favor of anyone till the time it doesn't understand what are its powers. So under section 19 of National Green Tribunal Act, the powers of the tribunal are very much derived. That is, as we discussed, that CPC is not 100% applied to it, but definitely court refers it for the adjudication of the dispute. So the powers are under that summoning and enforcing the attendance of any person and examining him with oath. So court can call upon anyone, it can be summoned by entity to call and get it examined in front of it on the oath. Requiring the discovery or production of documents. So the tribunal can order that all these documents shall be discovered and produced before the tribunal. Receiving evidence on affidavit. The tribunal can direct both the parties to file an affidavit by way of an evidence, if required. Then requisition of public records and documents from any office. The tribunal can direct any of the government agencies, state and central, to produce the documents pertaining to the title dispute from their office. And issuing commissions for examination of witness or documents. So tribunal can also appoint certain set of officers who can visit the affected areas and examine the witnesses and documents reports therein. Then tribunal can always review its decision. Tribunal can also decide the case ex parte. I hope you all understand what is ex parte. Tribunal is always empowered to pass interim orders. Tribunal can also pass an order requiring any person to cease or desist, then any other matter. So powers given under the statute are abundant to tribunal in order to control the environmental protection. But always keep in mind, what is the principle to establish this tribunal, which comes under section 20. So whenever we talk about NGT, section 20 is the heart of it. That is, the tribunal shall, while passing any order or decision or award, may apply to the principles of sustainable development, the precautionary principle and polluter pay principle. That is, that pollutant has to pay for the causes. Pay doesn't mean the money, for all the actions, illegal things what he is doing. And tribunal has to ensure that all the precautionary measures shall be taken to avoid any kind of environmental danger to the society. Against the orders of tribunal, parties can go to Supreme Court in appeal, that is within 90 days, which is any order passed by the tribunal. And tribunal also is empowered to get its order executed. And if the person fails to execute, he can be penalized for the imprisonment of 3 years or fine up to 10 crores or with both. So every special statute has an overriding effect. Since there has been many acts in order to protect the environment, and there are many other minor acts which are already very lame but may be protecting industrialists or anybody. use something which is hazardous. So this particular overriding effect gave powers to NGT to pass orders on anything which is rather taking away their powers. See, the provision of NGT shall have effect notwithstanding anything inconsistent contained in any other law for the time being enforced or in any instrument having effect by virtue of any law other than the Act. So before we go on to the cases, so these are the procedural aspects of National Green Tribunal. So if you guys have any questions, you can ask on that. The National Green Tribunal is not only to protect the environment, but also to ensure that rights of the people are also protected. And it was very important for the National Green Tribunal to ensure that the effectiveness of the National Green Tribunal shall be shown to the public at large. Also, all for the multinational corporations, other companies, those who are coming to do business in India, it was a setup done that you have to work within a discipline. You have to work within certain order to maintain the fundamental duties towards the country. So this is one of the classic cases which I will read it to you guys. Save Mon Region Federation and others versus Union of India and others. So in this case, an appeal was filed through an organization named Save Mon Region Federation in conjunction with the social activists in opposition to the grant of environmental clearance given to the 6,400 crore hydro venture. So this was a hydro venture which was established, which was to be built, and it was done at the cost of 6,400 crores. Government gave the clearance, they were to cut thousands of trees. But with this petition, the NGT came for the rescue and this project was suspended. The entire project was suspended by way of this judgment. This is one of the classic NGT cases which says that the NGT has powers to suspend any project which is hazardous to the environment. Another is Srinagar Bandh Apad Sangharsh Samiti and others versus Aklanka Hydropower. So the petition was filed mentioning numerous problems for the instructions to the primary respondent, that is Aklanka Hydropower Corporation Limited, to compensate of rupees 9 crores 26 lakh 42,095 for the hazardous harm suffered. And in 2013, the Uttarakhand flood which brought on the mass destruction of lifestyle and belonging is the backdrop of this case. So all these environmental issues, if you see, they are related, they are connected. The duty is to ensure that the ecological balance has to be maintained in the society. It's not only in the plains, going up into the mountains also. In 2000 massacre, we all know what happened. So NGT on this particular case passed the judgment saying that NGT has at once trusted the percept of polluter pays and made a personal entity prone to pay repayment and making them difficult to a code of environmental jurisprudence. So under this, in this judgment, they made the polluter pay to all the victims, those who suffered on account of Alaknanda hydropower project. And it was one of the classic examples where the polluter pay principle was applied, as we did under section 22. This is again one of the classic cases of Mitra H. Patel and others versus Union of India. So decided in less than a year, interestingly, which never happens in the Indian jurisdiction. This matter has been single largest landmark case managing the difficulty of strong waste control in India. So this pertains to the waste control. In this matter, Mrs. Almitra Patel and others had filed a PIL under Article 32 of the Constitution of India. I think I'm just talking to the wall, right? Well, we have just 2 minutes session left, so don't worry guys. Mrs. Almitra Patel and others had filed a PIL under Article 32 of the Constitution of India. Earlier, when the petitioners saw the instant and the pressing development concerning the practices which are currently followed for manner municipal solid waste or rubbish is handled in India. The tribunal discovered that the importance of the dispute became huge due to the fact that over a lakh of tons of uncooked rubbish is dumped each day, and there may be no right remedy of this uncooked rubbish that is dumped simply out of doors, the town limits on land alongside highway, lakes, nalas, etc. The whole society generated over 1,33,760 metric ton of waste each day as of 2012-13, and this has been growing with the time. The tribunal cited the requirement of conservation of this waste into supply of electricity and gasoline for use of society benefits, and deliberating the principles of circular economy. The tribunal, what the tribunal had, please consider this. The tribunal, after having evaluated each factor of the dispute, issued over 25 directions, and the tribunal directed each nation and union territory to put in force the Solid Waste Management Rules 2016 and put together plan in motion in phase within 4 weeks. Further, the tribunal directed the central government, state government, local bodies and all residents to carry out their respective duties below the rules with no delay. Absolute segregation has been made obligatory waste for strength of vegetation and landfill need to be used for depositing inert waste most effective and are concerned of biostabilization within 6 months. And tribunal ordered a prohibition and open burning of waste on lands which reduces the landfills. So, you know, the process which came that you can't burn the dry leaves, we have to divide which is a wet garbage, which is a solid garbage, then how the waste is to be discharged. All this was settled under this particular tribunal case, and also the rules were set up. It was Solid Management Rules 2016, in which the state governments applied all the principles. Another few important cases were diesel ban cars in Delhi, which you all are aware of. Recently, NGT has come hard on that due to AQI levels. Then farm fires, which is happening around Delhi. And then hookah ban, which was done. In this case, the interesting hookah case, what happened that the petition was filed. And I filed this petition. The name of the case is Madhindra Singh Sirsa and Union of India. To stop the hookah in indoors. Idea was to protect the people from the passive smoking because hookah leaves a lot of toxics. So Justice Swatantra Kumar was the chairman of NGT at that time. He passed the interim orders by applying his powers that hookah cannot be applied in Delhi across. So I'm sure if you guys were 2-3 years ago, there was a complete hookah ban where no restaurant holders were allowed to use hookahs. But ultimately, with the passage and the government realized that there is a huge business loss to the society, to the restaurant associations. So they made a suggestion that whatever hookah will be served, we will have a restricted entry. Anybody can enter with their own wish, we will not push anyone. So since, interestingly, this is the point which is again the point of debate, that there is no protection of indoor pollution in the National Green Tribunal or under Environmental Protection Act. There is no protection. So this was a question which was raised by the NGT to us, that, so Ahluwalia, do we have the indoor air pollution management system in the country? No, it's not there. So because of this, NGT was totally clueless what to do. That can we ban anything which is indoor within the premise, and somebody who has entered with his own wish. Like for the cigarettes, they have a separate chamber, so you can go in the cigarette room and enjoy the cigarette. But for the hookah, there is no separate chamber. Families are sitting, still people are taking talks. But they have gone inside that room with their own wish, knowing that there is a hookah service going on. So what to do? So they said, all right, so we will make simply a mention that this is the hookah area, that is the non-hookah area, which was adopted by various restaurants, and some are still adopting it and some are actually not. So again, NGT got failed on this aspect. to understand what is the indoor air pollution, and that point is still pending to be decided. At some point of time, I'm sure our legislatures will try to look into this aspect. So on this, we are more or less finished with the entire National Green Tribunal structure, how it works, what are its powers, how we can approach, what is the principle of having a National Green Tribunal, how they have been deciding the cases of pollutant pay and all that, principles what we have to follow, what is the overriding effect, what is the composition. So any questions on that, I'm more than happy to answer if you guys have.
Is there any question?
Yeah, please, yeah.
So do you think environment law as a concern is still a backlog in the Indian judicial system as compared with the other aspects of the society?
Well, I think we have come across a long way. We had all the basic tribunals of air, water. After that, then this environmental protection came, and NGT is one of the new act which 2010. So a lot to do. Still, I think the Indian judicial system. See, what I understand is that judiciary can only act on the statute. Judiciary cannot enact any new law. Let it be Supreme Court or High Court, because these are the court of constitutions. We can only interpret the statute given by the legislation to us. So legislatures have to ensure that how we can manage further the control of pollution, considering the par with the other countries. Because if you see what we have just gone through, it was the Supreme Court which gave the recommendation to establish National Green Tribunal. It was the National Green Tribunal which suggested that we should have a solid waste rules to stop the garbage the way it's going on in the country. So courts are doing the best whatever they can. But what is the legislative intent, that is to be seen. And we as lawyers, we really can't comment on the judicial process because we know the limitations of the court. But yes, as a lawyers, we can always raise our voice to the legislatures that we should have these further developments to protect the environment at large, which can be enacted later on by the judicial system. Yeah, please.
So my question is, what is the judicial system providing to our eminent lawyers who are conscious about protecting the environment and are filing pro bono cases?
Judicial system. Sorry? You're saying judicial system?
Yes, sir.
See, judicial system is same for all. Whether
So
it's
basically the lawyers who are conscious about protecting the environment and have been filing pro bono cases. So what is the judicial system providing them?
judicial system providing them nothing.
Are you not helping them? Like, what are the basic provisions, or like how is are you supposed to?
See, the court has to understand. Now, maybe you are finding that you are right. Court has to value both the parties. One, you might be a good, but for the other one, you are bad. So, when you are approaching a court by way of a petition, don't think that you are right. That's why you approached it. You have to get something adjudicated. So, I'll give you the example of hookah. Right? So, but court ultimately said we cannot ban it on a permanent basis because it is disturbing the business. So, court has to evaluate. Court has to see what can be given and taken away by the society. So, per se, lawyers don't get anything. Our duty is to plead the cause of a complainant or of a petitioner. But the rest we leave it on the court to decide. Right?
Thank you, sir.
Yeah. Any other questions? Yeah, please.
First of all, good evening, sir. My question to you is, what could be the other role of judiciary in protecting the environment besides PIL?
Well, you see, besides PIL, we have NGT, that is of course there. But I also think that judiciary should also run certain awareness programs by calling business houses, by, of course, law students or other students, business students, those who are going to join business in future in any form, to make them aware what are the powers judicial system has and how they should be very much in control to ensure that the laws are followed in the spirit. So, all the processes are done in the interest of the country, not in personal interest. Until the time people, they don't know about these things, they will definitely not follow it because they are unaware of these issues. So we should make more awareness by way of advertisements, by way of having certain seminars, and of course judiciary can always make a big contribution by recommending that what kind of laws are being laid, and they should be cautious about these facts with the precedent that have been given by the judicial system. Yeah. Yes, please.
Sir, do you think the government is restricting the judiciary for implementation of the policies related to environment protection?
Like
एक साल में प्लास्टिक बैन होती है, अगले साल फिर से शुरू हो जाती है, पॉलीथीन बैन होती है, फिर से शुरू हो जाती है, तो कहीं ना कहीं गवर्नमेंट रेस्ट्रिक्ट करती है जुडिशरी को.
See, whatever orders are being passed in judiciary, that ought to be followed strictly as per the statute. But in case there are certain sectors which are not following, it is for us as citizens of the country to bring it back to the judicial system and make them aware about this is what is not being done, and then let us see whether the court does it or not. I think to a certain extent, if we see the COVID times, if we see what is being done as far as diesel fuel issues are concerned, there has been very lot of strictness going on. But with again certain issues which is being left out, I think till the time we don't approach the court will not be able to do anything. So the best is to approach the court and get the remedy out. Anything on NGT or environment protection, guys? Are you? All right. Thank you very much.
Thank you, sir. Now I would like to invite Dr. Kalpana to present a memento to our chief guest as a way of thanking him to spend his precious time for us.
I would like to thank Vice Chairman Sir, Shri Anirudh Jindal. I would like to thank our Dean Ma'am, Miss Prachi Jindal, Director Sir, Professor Vikasnath Sir, who has always supported for this kind of programs and events. Juristry obviously provide an opportunity to the students to know about the contemporary issues and challenges, and the knowledge of experts that always enhance the knowledge. We are teaching in the classroom, but what the expert is saying, who has practically worked in the field, obviously that is enlightening a student as well as the faculty. Today, I would fail the duty if I will not thank my students. I know you are impatient to leave, but your patience, your presence is matter for us, and obviously you make it possible in spite of all the difficulties for this event. I would also thank each and everyone who has supported in this event and make this a wonderful and memorable event. Thank you very much.